Um. So, look.
See,
I'm
Mr. Chavez, I hope you don't mind I sit on this.
no.
No, of course, sir.
This is absolutely perfect.
Did you
So,
lock that there, Adams?
Sorry? Yeah, I did.
Did you
Yeah, it's locked, yeah.
I'm going to be rather transparent, rather blunt here. This is not intended to be any kind of personal attack on you, on Crane, on just whatever the entities are involved, because I do think the lawyers play kind of a role in all this. I have been. I'm going to give you some background, so there's going to be a little bit of yap here, right? But I want to like kind of paint some perspective. I've been waking up a couple hours a night, attempting to, assist the individuals down in the cells. To my, I've been away for a month prior to that. But what I noticed is nobody's calling any lawyers, right? And this has got me confused. I'm like, what? How is this possible? I then come to find out that not only are they not getting called down, but there's not many lawyers to begin with. So I start polling individuals, both individuals that have eaten charges, as well as lawyers when I do see them in the yellow pages. And the picture that is being painted to me is they go in the cells, and it's effectively a waste of time because there is no conversation that transpires or some sort of let's call it, I don't want to say like a bench trial, but like this sort of I'm sure you've seen this before, right? Where the lawyer and the officer sort of argue some of the charges and preemptive to what may be a bench trial if there's a heavy disagreement on said charges.
Son, yes, I understand what you go with
Yeah.
this.
And so I guess that paints my first question, which is this something that is no longer an intended practice? Or is this possibly a practice that is indirectly enforced by, let's just say, poor training by the department? That's like my first question. The second thing that I notice is I go and try to get a statement written for a civilian who is a victim in a crime where the officers may have been those that committed it. I'm not going to go into too much detail in case you end up overseeing the particular case. But in doing so, I find that, number one, they don't want to take it. Number two, when they do take it, they're saying they need 5 days in order to produce the report in which the statement is being produced right there, arbitrarily. They then go and complain because I'm complaining and trying to explain. I get an answer as to why you need 5 days to give me something that's being written right now. Immediately, there's a call being made to the head of bar and to Siobhan Fitzpatrick, which it has me disillusioned. And I'm saying, well, now I'm asking myself, why do they think this is even a thing? Because that doesn't even pass like basic logic and common sense that you would need 5 days to produce a document that's being produced right then and there. I then go digging into legislation only to find that the Freedom of Information Act isn't even defined, but it is written as a offshoot document outside of legislation by the past head of Bob Moulton in what was likely a drunken state simply due to the grammatical spelling and errors that completely fly. It looks like if I had woken up drunk and wrote something in 2 minutes and then passed it off. So inherently, FOIA doesn't actually exist in this state. And now I'm wondering,
No, it does not, actually.
How does no one notice this for 6 months? And I notice it just off this bullshit, right?
Son, it's
And
like
then,
tonight, actually.
Yes.
It's with the whole weapons license.
Yes.
Mhm.
Now one could say that now, and this is why I don't make this a DOJ thing, because I inherently think it's the job of the lawyers to actually find these holes and push them, be it in a hearing, be it in, taking, there's multiple avenues by which we can take it to put these things to light. Which we do plan on doing so, which is where I'm going to get the permission that I would like to start mag dump season on the docket and kind of give a preemptive warning.
Call something else other than that, please.
I'm down for something a little bit more like, it sounds funny, I think. Docket season, maybe. Where if I am not, I'm being transparent here so you know what's coming, right? And I don't want this to come across as like, I'm just going to use a loose term because I can't think of a better one right now because I'm awake for 13 hours. But I don't want it to come across as like me abusing the system or being like oddly toxic towards the judges, because this is aimed at you, but rather would be a weapon to say, hey, if you're going to go and charge my client on something and you cannot actually articulate probable cause and are not considering the evidence that we're presenting to you in the cells, I will throw that on the docket the same very night, forcing a hand to produce the paperwork required. And I will continue to do that and use that as an avenue to say, hey, FOIA needs to be defined. Now, granted, I could go through a different avenue, which is going through the council and whatnot, but with all due respect to this room and them to the greatest extent I can, it sounds to me like it's a bunch of children that are playing like the third, like, excuse my example, but the examples are in fucking law. They're LARPing is like the fucking Third Reich right now. You guys do know that, right?
I have no idea what the hell Third Reich is, so it might have to rephrase that one for me.
World War II. Anti-Mime Act. The clothes that are being wore, the fucking photos and shit. Like, am I supposed to pretend this isn't happening and like, oh, that's great? No, fuck that shit.
So what you're saying right now is the same thing that towards the end, before the city imploded, is exactly, I think, what Crocodile Steve did. About 15 cases on the docket. Appeal. Every one of them.
Yeah. So
they wanted everything put on there. Do the exact same thing that you're considering. That's fine. And that is within your right and your client's right to do so.
Who is it that tried to do this?
Crocodile Steve, a long time ago.
Really?
Yes, he did.
I think there's a man that ended up firing him. Too bad he got fired.
Was that yourself?
No, I couldn't have fired him. I just read it in the papers. Like, I guess he got fired twice from the same guy. The guy was going on a firing spree, if I recall. But anyways, so that kind of, I know I'm kind of like dumping a bunch of different like things on y'all's lap, but I'd like to hear your opinion on these things, like beyond like actual personal opinions on this.
Here's my side of it.
Yeah.
If you have the charges there, brought forth upon it, actually, let me back up, right? We live in a city and a state. That normally what happens is you go before a judge, you hear charges, things like that, they're brought forth before you're actually convicted of them, right?
Yep.
It doesn't happen here. You're convicted before that point most times and sent up to prison, and you're told to appeal them. Am I wrong?
Yeah, 100% correct.
So we have, unfortunately, a little disparity from where we are used to things, or things have happened in the past, or shall I say, outside influence.
Yeah. We're using part of a system designed to work one way, but we're making another part work a different way.
Correct. So, when things are left vague, when things are by nature designed to have you argue them, but is definitive at that point, what's the point of having them vague? What's the point of common law, my friend? Let me ask you a question there, Mr. Chavez. Are you aware of a Brady violation?
The one that doesn't exist?
correct. It doesn't. It does not exist. It did a long time ago. Might have been used then. You know how often those things actually come up now? They still do at times. Just because it was one way previously doesn't mean it's the way now.
Mm.
And so when I sat there tonight and had conversations with individuals in regards to things that were happening, I said, why are we shutting some of these things down?
Thank you.
If they are vague, and the point is to argue, as you said, as such, and valid points are being made. The hell is the point of doing these? Frankly.
Yeah.
Just first off.
I
Because,
Hmm.
take for example, the weapons license.
Bro,
Now, this is my own personal opinion.
he's so right. I wish he didn't step down.
When it's said on there that it is for anything.
That's exactly what we were saying.
Yes, it can be existing as common law, per se. It is not established anywhere. When common law is one of the ways that we have as part of our authority within the city, as Article number 1 of the Constitution there, to enforce such things. But he pointed out pretty damn well some faults in the foundation. And so when it came to a long pause there, in regards to having discussions about, I don't know what the hell it was. Let me look at my notes. Yeah, the penal code and inappropriate attire.
Yeah.
That's when the conversation stopped. I can understand where it could be seen broad in nature. I can also understand where he was going with things. But they wanted it shut down. I say, hold on. You have to take a look at how he has been doing this previously. He starts very wide with his questioning, and then he narrows it down and makes his point, which he's getting his own narrative out of it, essentially.
Yeah.
Which is personally fine. But why are we disallowing that conversation right now? Because we've allowed it the entirety of this time. Because they didn't want to hear it and they're going to be there forever. I said to them, no. This man has treason, which is a capital offensive to the law.
Yes.
If you want to limit this man's time in front of us right now, why the hell are you here? If you don't believe I actually said that, I did.
Yeah.
I believe I said that to Mr. Chavez as well.
Yeah. It's Bailey, it's almost like you were in the conversation me and Robin were having. Because, you know, the law is written in such a way that, there's the phraseology, letter of the law, right? Things are defined a certain way. And then there was the very old age spirit of the law. But the problem becomes that if sort of ad hoc decisions of, if someone is making a point, as you say, and they are shut down due to, what was the phraseology that was being used? If his argument, expediency, it being shut down because it's too nuanced, too technical, or whatever. Semantic. Yeah, semantics. That's what.
Hold on.
Semantics.
I'll say a lot of the semantics were, in some capacity. I'm sorry to interrupt you there.
Yeah.
When I think, and I did say with this, the semantics of the objections at times were unnecessary.
That's fair.
Agreed. But if the argument is based on fighting semantics, that inherently is challenging what is currently written. And if that argument is not being fully presented, well, then how do you birth any precedent to begin with, right? It ultimately does become a pretend letter of the law judgment, when in reality, because the arguments that counter how that decision was made or shut down, well, then it actually is a spirit of the law judgment. You get what I'm saying?
The two stand in hand.
Well, correct. That's
They're
why
meant to
it's,
duel each
sorry.
other to create the precedents and the common law.
Yep.
You can't have letter of without spirit of the law.
Okay, but how do you get there if a man who is facing treason is making an argument and poking a hole that argument gets to get shut down before the point is made? Because if it does, then that point can never be considered in deliberation, and it cannot then birth any sort of legislative changes, any procedural changes, or any
I believe that a judge can tell them to stop laying their foundation and get to the point. I don't believe that they should be allowed to tell them to skip.
Yeah.
Mhm.
Okay.
And if
I
they
would
feel
agree
like
with that.
the questions that are being asked are absolutely 100% necessary to their point, they're laying any sort of foundation, it's necessary. If
Right.
they're trying to get to a point but laying the foundation, that's when we make the judgment call of, no, we're not entertaining any objections from the other side. Just get to the point of this line of questioning.
Hmm.
Because
Gatsby,
yeah.
listen, consider, was he not doing that for majority of the night?
Yeah, exactly.
He was. But there was a lot
And-
of repetition of starting broad and going in that I think he could
Yes.
have just gone straight in.
Sure, correct.
Should the judges have allowed him to just do that and told prosecution to shut up?
Here's the thing.
Yeah.
Those points did become valid when he got to them. So
Yeah.
I wanted to hear it.
Yeah.
They
Yeah,
did
like
not.
The point about the point Soze was trying to make with the whole clothing regulation thing was about how Bones chooses to enforce one thing but not another.
Correct.
But Judge Jackson seemed to assume a different line that Soze was going down and just shut it down.
I said exactly to them in that meeting and that when we were discussing, do not see where this is going, my friend. Do not see that he is going with this one question towards selective enforcement.
I'm gonna be rather blunt here. From the moment the two other judges, I don't know them very well, step into that courtroom, some of the remarks that were made already indicated they had a preemptive stance as to their position of the case. And what came after that was nothing more than assisting the prosecution in making their point and shutting down the defense, which consisted of a trooper that, as far as I know, doesn't have a lot of experience in court. Like, he did fantastic, but he's not a lawyer. That he was shut down at every opportunity that was given. And I don't think the prosecution should ever need to be allowed more time than the defense, because it is the defense that is got their liberties at stake. And that case did not make me very confident in the legal system. If that's how things are being done.
When
Can I
Judge
ask you a
Jacks-
question as a judge that wasn't there for most of the
Mhm.
proceeding? The drift I'm getting here is that Soze was doing most of the questioning himself. Is that correct?
Yes, he
Yes, it
was.
was.
Okay.
How is there
as
sort of a safety net? Is that what you're going to ask?
sure, I'm more positing on what level of participation you had in crafting his defense. And if maybe you raised the argument that Soze is not a lawyer, and you're right.
Mm.
But the two of you gentlemen are.
Oh, so I'm not. I wasn't entered in.
Yeah,
I
Nino
came in last
came
second
in-
to observe.
yeah. So in terms of crafting our defense, me and Soze did speak, and we sort of both we both sort of pitched our defenses to each other. He said what he would think a defense would be, and I sort of gave mine, and it lined up. And I felt that he would be able to give the more persuasive way of questioning, as opposed to me in this instance. Hence why he was doing most of the questioning. I was
So the
there.
opinion was that Soze would have a more impactful. He'd like more of an impact to his questioning, right?
in
Absolutely.
his manner of speaking and how he would sort of present the questions. And I was there as a sort of legal safety net if he missed anything.
Okay. I wonder. The only reason I ask is if I wonder if there was a missed opportunity to tighten up while still laying adequate foundation to get to the points of those questions. So maybe
Yeah,
those two didn't get annoyed.
I can agree.
I don't know. I
Yes,
wasn't
there
there for
was.
most of it.
Absolutely,
so.
there was.
Yeah, there was, and I should have done better.
I don't know that that necessarily excuses anything that happened either.
Like,
Yeah.
for me, when Judge Jackson, in one of the very initial sidebars, mentioned about not wanting to hear an argument about state authority, that told me that he had a preconceived idea of what the defense was going to be and what the prosecution was going to be, and he was inherently coming from a position not in the middle.
Here's a part of that. I'll also give you a little bit side to that. When you start to say, can you define the borders of the state?
Yeah.
Frankly, this is not, we're meeting our not forefathers here that brought forth upon this nation to distinctly explain what the hell the actual borders are. Right?
Yeah.
Now, I don't discount the fact that jurisdictionally, is it different? Is there something that gives power to the BCSO that should be written in there at some point? Possibly, yes. Those are valid points to make. Everything can be a valid point.
Yeah.
I don't want to get into those conversations of what defines the borders of San Andreas.
Yeah, that was more of a sort of petty thing for me, because like part of our defense was the Constitution is called Los Santos Constitution. It's the city council, not the state council. You know, that was our whole, well, not our whole point, but it was part of it.
I mean,
Well,
it's a fair point too.
It is. Now, I appreciate those things that are not, because it is thought of one way. Doesn't mean that it is definitive as that how it should be. Oh, by the way, your client said he's going to jail afterwards. He had some jail and prison comment. Anyway, that's besides the point. Here's what I'll say with this, right?
Guys, don't say weird shit about streamers or OOC stuff. This is RP, guys.
Here's why I stepped away, right?
Yeah.
When those things got shut down, I mentioned to them, if you're not willing to hear this thing out and you just would like for it to be...
Oh, yeah, we have plenty of option for mistrial.
Why the hell did you take it? Why is it here? There's also comments brought forth about a mistrial.
Yep.
Where Jackson had said, yes, it could have been mistrial. And I said, I don't want to be here then. If you said yes, that's enough that I wanted to hear. I no longer want to partake in this. And I will step away. If we don't follow the procedures, Jackson.
What? Why?
Everything that went off before that and everything else, etc., it could have been mistrial. I said, so why did it happen? So why do the procedures that we have set forth in front of us, why don't we follow them ourselves? Because we just got done with a question of, well, leading towards selective enforcement.
To be frank, I had a motion to mistrial written up for the docket. When your client decided to text me and tell me that I would be motioning for a mistrial, so that conflicted me out of actually doing it.
Yes, but Jackson's literally said it while I was there.
Okay.
Believe me, I was asked to do this morning. Before this, I was flown out. I was not around. I have not been around for like last week. I have zero notion of what the hell this was, right? I was asked this morning, could you take this? I said, sure, why not? I have no idea. So I show up. And he says that during it. So why do we not follow our own procedures that we set forth in front of us? Because if we can't do that, I do not want to be involved with this. He said, because I wanted to hear it. Said, excuse me. You just wanted to hear it.
Could have still been mistrialed and refiled and heard later.
Oh, it should have been mistrial the moment I walked out.
Oh, trust me, we already...
Why the hell didn't you do that?
We felt like the judges wouldn't want to hear it.
Yeah.
I'm sorry. What's Wayne Gretzky and Michael Scott say?
Yes, I suppose. Yeah.
At the very
I
least,
did
it
bring
was
it
an
up
on court record.
Better
Should
for you to
you
have it on
have
record.
wanted
Multiple
to
times.
appeal that
Yeah.
you have the motion for mistrial flat out denied after one of the judges steps down.
Correct.
My
Because
understanding
I
is
literally said to them,
Yeah.
I do not want to be here if you say that this should have or could have been mistrial at some point.
well,
I'm not
given
going to do that.
given this further context that we've gotten, I believe Rick can go on the docket and file that motion right now.
Well, you might want to
Some-
work with Slacks then as well.
Yes, okay.
Here's the other part to that.
Hmm.
Because I had ruled on objections, because I had asked clarifying questions, because I'm no longer making a decision in their own deliberation, it should have been at that point.
Hmm.
Regardless. Because my involvement there had already possibly changed the outcome of a trial, which I stepped and recused myself from.
Mm,
Understand that?
mm.
Do with that information.
What this is at the end of the day is a very, very hard learning lesson for you of how to prevent this from happening again. You can't change the past, you just learn from it and work to do what you can now to keep it from happening again.
I missed what they said here.
I think there's a lot of lessons to be learned from this.
Oh, yeah.
Well,
Not just one.
But don't try and force it out all at once. You're going to overwhelm yourself. You're going to make it too hard on yourself. Just take some time to digest. You don't have to figure out every way that you could have improved right away. You have time. That's one thing you always have. So don't be coming down on yourself, trying to think of every single way that you screwed up. Just take the time to
I don't know who she's talking
understand
to.
what's being said to you right now and use that.
She talking to
help
Baily?
you later to just kind of digest and figure things out for yourself.
Oh, Robin?
I'm talking specifically to you because your face is an
Yes.
open book.
You're talking to Robin? This one?
Yeah, well, he's the one who's looking incredibly disappointed right now.
Oh, yeah. I mean, wait, just to make this to get this, you're telling us, despite the fact that we just learned this information, that Robin can't go and file
No,
for.
we can.
Oh no, you can
Oh, yeah,
take
absolutely.
action
Oh,
right
okay.
away, but
Yes, they
Yeah.
can.
don't be trying to figure out what you're trying to take away from this all at once. You're going to overwhelm yourself and you're going to miss the trees through the forest or the forest through the trees.
I don't think there's a forest. Is kind
There's
of
always
what
a
we're.
forest.
If it's a forest, then it's a bunch of like random plants that haven't been watered for 6 months. Wait, what? How long? 7 months.
Which is
Not on, and that's not on you. I want to make that very clear. We were talking about that in the beginning, Gatsby, is that this isn't a DOJ thing. This does fall on the lawyers as well. To be that there's a lot of options that we have on the table that, and Robin, this is no attack on you or the other lawyers. If I look around at the pool, a lot of folks may not know that there's tools that we have available to us that have been used in the past, and I have no reason why. I don't see any reason why we can't use those tools today. And
Yeah,
well,
that's fair.
until you tell us to stop. So there is options on our side. I mean, I'm gonna say it again. These last two head of bars, they haven't done jack fucking shit, and that's gonna change real fast.
I agree with you
Yeah,
on
I'll
the
give that-
part of the tool side of that. And that's why I asked you about the whole Brady violation. I said, does it exist? Most
Yeah.
people with the assumption that possibly it could, but it isn't
Yeah.
known. So what truly becomes common law at that point?
until the argument is present.
Correct.
Mm.
Make it come.
Absolutely.
Exactly. It
Um,
doesn't exist. It used to, sure. Was that someone's tool in the past? Yeah, absolutely.
Mm.
It's not a tool right now.
Yeah.
Doesn't mean the fact that it couldn't be.
Yep.
But who's the
100%.
hell to know, frankly, if it is or isn't.
There's
You
one
want from a
Hmm.
very, I want to say established, because there was there was enough faults there in the past before the whole war thing.
luckily I wasn't around. I was on an island somewhere. I heard
Fair enough.
there's a very, very brave man that, made some very hard decisions amongst a series of terrorists.
Oh yeah, I think I know a few of them as well.
God bless President.
uh, and one brave
But wait,
EMS,
hey.
so I hear.
Walter Christmas may or may not be a war hero. Depends who you ask.
One man's terrorist, another man's freedom fighter.
Yep, not wrong.
And one man with a pen sitting at the homeland signing off on all.
Yeah. Oh yeah. Oh shit. Yeah. I saw your name on those in those history books. I remember that. You were right in the thick of it, weren't you?
Yeah, I was.
Anyway, what I was trying to say is that
yeah.
there was a little bit more structural tools, as you put it, available there. And as we were,
Norman was so
one of the
sick
first
back
things I
then.
asked Crane. I said, "All right,
Norman was a
these things
legend.
exist?" No, they don't. I got into one of my first trials, and they said, "I want to do a Brady violation." I said, "That doesn't exist. I'm sorry, doesn't happen." The whole purpose of the head of bar, the city council, what we have was to establish things that were necessary and to shape them to what we've had. Unfortunately, we've fallen into a state of complacency.
Yeah.
Or, frankly, if it's not even complacency, it's a lack of critical thinking.
Agreed.
And this isn't just from one side, it's from all sides, ours included.
Yeah. Yeah.
And I think
100%.
that was shown tonight, which is not what should happen.
No.
Just because it's said at some point doesn't mean that is truth.
Yeah. Yeah.
As pointed out multiple times in the Soze's whole defense. Why is it that way? Not too many people ask the question, why? And these happen more. It doesn't.
Yeah. Yeah. I think that was made very clear when the judgment came in and those explanations were not present. Because if they could not be presented, then, maybe how much thought was really put into it to begin with.
Correct.
One last thing I wanted to touch on was, as I understand it, there are apparently some case laws that have been made, but they're not available. And I imagine if they're not available to us, they're then not available to the public, and therefore, are they even codified?
They're available to us, but not the
Should have been
public.
fixed, Nino, or no? Because
Sorry,
it is
say again?
available to the attorneys.
Yeah, but
Crane is fixing my shit, so maybe I just don't see it.
I think our NDTs are broken right now. At least mine
Yep,
is.
yep, they are.
But
Mine's working.
The common law precedence report is available to members of the DOJ, but not the public. And I would assume that the public should be able to view that on their own without needing to contact a lawyer.
Yeah.
Or am I mistaken?
I can review and see if that needs to be placed. The issue with making more widely available than it currently is boils down to something pertaining to who has access to amend such a document.
Yeah, it's like
more than anything else. It is intended to be a
it's-
living document. As you've seen in the past, I'm pretty sure I'm the only one that's ever touched it. But
it's the same as
technical. It's technical. Riffraff is what the issue is.
It's the same as the sort of the DOJ advisory on loans and like the list of government buildings.
Or the FOIA process, or the Malton process.
People like right? The public can see that the report exists, but they can't see what's in it.
Well, nobody can see anything right now, apparently.
Oh, yeah.
But yeah,
On a normal day.
no, I know what you're saying.
Yeah,
Um,
I mean, once again, Norman, if that case law is not public, then inherently it shouldn't be considered law because you're now
I don't
entering.
disagree with you.
It
I
becomes
don't disagree with you.
it becomes draconian, right? Like, how do you know you did something wrong, right?
Yeah, I don't
If
disagree
you
with
actually want to be a person within this city and there's something that has been established as a precedent and set as a case, and you can't personally read it because you're not there to understand it, and you get found guilty of the same damn thing or whatever the hell it was,
Yeah, like if someone
why
does
the hell is it there? And
Yep.
so, listen, you have to understand, yes, we do have limited systems that we have right now, but I don't think those should be valid unless there's some way that we have put them forth that everybody can view them.
Well,
yeah.
In matters where I've established any form of a common law, I've made the point to write it out on the docket as well. Which
But nobody
is
is
its own
looking
headache because
through the
nobody's going to
whole
look through
damn
pages and
docket.
pages and pages of closed cases to
No.
find it,
Yeah.
right?
So,
Ain't
yeah, it's
nobody.
hard to know which sets a common law precedent and which doesn't.
I mean,
Even myself, I'm not looking through all them.
Yeah.
wait. So,
And I don't particularly look at all the damn case laws either. If there's one way to find it, sure, fine, whatever. Done.
So, to ask
but there isn't.
like a bit of a technical question, my understanding is that the legislation can only be updated by those on the city council. So, in other words, like Crane.
Just Crane, actually.
Oh, it's just Crane. Okay.
Yeah, it's just Crane there. Yeah.
But then the things under reports is going to be separate altogether. But y'all are able to tag it, I assume?
Yes.
Okay.
We can tag it. We've got a master that you can get to that we get you the number of. That'll branch to every relevant document.
I
for
would
your reference.
I would wager to assume that there must be a way in which
Well, then.
there are.
Sorry, it had a really nasty looking mosquito.
I would say that
those will get you.
it makes inherent sense. If I was, I'm not trying to like pitch to become like head of bar and thing. These are hypotheticals. That the head of bar or Crane should, and we can talk to him about it, push legislation to the effect of common law is established, and boom, here it is. And so when y'all, let's say, new or not common law, but case law is established, that case law gets sent to them, right? They look at it, and they add it in. Yep.
Yeah, I don't think that's a terrible idea.
Because I mean, they meet every week, right? Like, they're just doing something they're gonna do anyways. There's no reason why it shouldn't be a part of their procedure. Literally, laws changing, it is their responsibility to do it. And if the legislation says, well, if it's not in this thing, it's not real, I think that's important.
Because there's been 4 findings for that I personally have published. Those should be available in a more accessible manner. I can have the conversations and work out the details on that.
Okay.
Because that should
like
probably a little bit more surface level.
For example, like the expungement legislation has been changed and amended, and everyone can see that. So I think, like technically, like on the technical side, I think it's possible.
Oh, it is. It's just it'd be a matter that the document that you're referring to needs to be published as legislation and needs to be maintained.
Yes.
Yeah, I agree. I mean, this all goes back to the point, right? That complacency, laziness, etc., all parties are kind of guilty of it, because there was avenues for the lawyers, avenues for every branch to do these things, and perhaps now's the time to start doing it. Okay.
I do agree. Yes.
All right. Easy. Well, I don't have anything else. You there at all?
No, I don't. I appreciate the
the
teaching.
Hell yeah, I appreciate it.
I hope the bar for you, gentlemen.
All right.
Of course.
All right. Y'all have a good evening.
Yep.
You as well.
Good night.
Always a pleasure, Nino.
Yep,
Rob,
likewise.
you're on.
Do you want to take care of that right now?
I need to go get food because I ran out halfway
Yeah.
through the case, but yeah, I can
My-
give Lancaster a call.
Honestly, if you're able to do it within the next 15 minutes, they may be able to sign off on it right now. We can get him out of
Yeah,
jail.
hopefully. Actually, I need to take a nap because everything's broken for me. So yeah.
I'm gonna be pretty honest. I was gonna be a bit more forceful in saying like,
Mhm.
"Hey, let's do this right now." Transparently, I didn't know exactly what he wanted because I wasn't sure if he was like trying to get, not want the mistrial. You know what I mean?
Mhm. And then when I questioned the judge, and he's like, "Are you accusing me of stuff?" It's like, well,
I did not appreciate either of them, especially the fucking dumbass.
yeah.
He makes a lot of sense, and maybe I don't know.
Maybe somewhere else.
Yeah. Like maybe cases where you got like I don't know, like Eugene Zuckerberg or like some
Yeah. James Randall. Those
yeah,
type of
James
people.
Randall, exactly. But when it comes to serious matters, if you're saying dumb shit like that, honestly, you should probably be assassinated.
Yeah. Well, this is just my house across the road, so I'm gonna take a nap in there real quick.
Okay, easy. I'm gonna find a way up. Do you want to meet at Bolingbrook? I'm gonna go let them know what's happening.
Yeah, sure. I need to
Okay.
go. I'll take a nap and I'll call Slacks or Lancaster and see what they're doing.
Okay. I am gonna be honest with you. Fuck what they want to do. This is my opinion. I don't think we should wait for anyone, and you as the attorney should just do it, right?
Okay.
Like what is the PD's? He's in the department that put him behind bars.
Yeah,
Who knows
sure.
what the fuck they're cooking? You know what I mean? We get them
Uh,
out if they want to do some
alright.
other shit, by all means. But this is your case. You know what I mean?
Yeah, sure.
So,
I'll just go take a quick nap.
alright.
And we need to get food from the food court, and then we can go
Okay.
see if Thursday's still
All right,
awake.
easy. You know what? I'll wait right here for you then.
Alright, chilling.
All right.